This is the first intermediate session we're hosting, fair housing webinars. It's about compliance, fair housing complaints, and we might touch a little bit on COVID-19 and kind of some of the implications that are making themselves known with this. So first of all, I want to thank the following folks: the U.S. Department of Housing and Urban Development. They are the ones that funded a lot of this work. Attorneys David Penny and Eric Stevens for their time and experience. These guys have been around Idaho representing landlords in fair housing cases for a long time. I've had the pleasure of working with both of them over the years, and there's not much they don't know about how fair housing works in the state of Idaho and elsewhere. Eric works in a lot of other states as well. I also want to do a special shout out to Christina Carlos with IHFA's Marketing Communications team. She's really been instrumental in getting the word out and helping me kind of monitor all the chat room today. Thanks again, Christina. Let's see, so our goal today is really to increase awareness of fair housing law, rights and responsibilities, and thereby reducing the amount of injuries or violations which can bump up the cost of housing for everybody. So ultimately, we want to make sure that we have more housing opportunities for everybody in Idaho. So here's our acknowledgement and disclaimer that talks about the grant that we've received from HUD to help fund some of the work that we're doing here. These are the work you're going to see here. The information and presentations are the work of Eric Stephen and David Penny. So they take full responsibility, right, guys?
Of course.
Okay.
Along with Eric Kingston.
Oh, yeah, right. All right. Finally, here's some housekeeping, or not finally, but almost finally. Housekeeping. So we are recording this session. It will be uploaded to YouTube, to IHFA's YouTube channel in the next few days. And we will also send links to this video, to the chat room contents, and to any related materials that we discuss. We'll send those out to you in the next few days. We're going to have everybody muted. Thank you for keeping yourselves muted so we can reduce noise. Also, you can rename yourself. If your current name says, you know, Martha's iPad, you can rename it to Martha Mitchell or Martha Washington or whatever your name is. And then you can also turn your video off if you'd prefer to do that. That reduces some distractions for you, and that kind of helps reduce the potential for embarrassing situations for some people, I think. Please type your questions, comments, or resources, any resources you want to share in the chat feature down below on the bottom of your screen. And then Christina and I will be monitoring that chat, make sure we kind of understand like who's asking, or you know, the kinds of questions we're hearing, and then consolidate some of those and pose those to the two presenters. And remember, as soon as you hit enter, it's not like a hard return on a regular word processing. It will post your comments, whatever you've typed, for everybody to see. The session today is in 7 parts. After part 3 or section 3, that represents about the midpoint of the session, just kind of an FYI. We'll try to make time and field some questions between each session. Hopefully that'll work out. We'd like to make that available. Also, if you don't get your question answered today specifically, you can always sign up for the advanced session on the 24th. And that one is going to be more kind of free-ranging. Eric and David have offered to discuss more kind of specific questions from the audience in more detail. And I think that should be pretty useful for everybody if you've got pressing questions or concerns. Again, these are the two stars of the show: Eric Stephen with Stephen Law Office in Spokane, Washington, and David Penny, who until a couple of years ago, was in private practice and represented a lot of different housing providers in civil rights defense cases. Now works for Tomlinson as their general counsel, and both of them are real experts in this area. Again, my name is Eric Kingston. I'll be the moderator. I'm part of the the Idaho Fair Housing Forum, and have worked on fair housing issues with IHFA for a couple of decades now. I want to give you a little bit of context before we launch into the specifics. So fair housing, basically, aside from being a civil rights law, fundamentally is about providing access to economic opportunity for people. So that's something to kind of keep in mind as we all work on our own aspects of fair housing law. Ultimately, it's to provide housing choice and create more stable, financial situations for people, give people economic opportunity. IHFA and the Department of Commerce work on several annual and every 5-year reports and plans that look at the state of fair housing in Idaho periodically. The most recent one is 2017. We've got another one that will be coming out in late 2021, early 2022. And in the most recent Idaho assessment of fair housing, they really looked at an economic opportunity approach to kind of frame how we look at fair housing. And again, it's that concept of housing choice that is really a key to looking at economic opportunity for Idahoans. Again, I'll just kind of let you take a look at this quickly. But the bottom line is, fair housing gives everybody the right to live where we choose and where we can afford. Bottom line, those two things. And that housing choice is really fundamental to the success of families and individuals and households everywhere. And just want to, give a shout out again to Christina Miller at HUD. She's our sort of main contact for this grant. And that's some information. Again, you'll get links to these presentations, so you'll have all the contact information that we provide here. Again, a couple of other resources for you: fairhousingforum.org, something that IHFA maintains as a courtesy to everyone involved with fair housing. So whether you're a provider, local government representative, a consumer, there's something in there for you. And I would encourage you to take a look at that and provide feedback if you have questions about it or see something that you'd like to see updated or you have questions about something. Idaho Housing and Finance Association also has a new fair housing section at idahohousing.com/fair-housing. And so that we're going to be posting a lot of new information on there as well. All right. So I am going to stop sharing this one. And I'm going to do we're going to take about 20 seconds here to do a quick poll. And this is your chance to tell us what you know about protected classes. So go ahead and fill that in as best you can. We're going to take about 20 seconds to do this. Don't be shy now. Oh, I see. We're getting some good participation in this. That's great. Okay, 5 more seconds. All right, we're going to end the poll now and sharing the results. So can everybody see those results now?
Yeah, we can see them. Okay,
good deal. So it looks like one of the winners here is source of income. So oh, so Eric and David, what do you see there? What jumps out for you?
Well, a lot of people obviously don't believe source of income is a protected class status, and I don't believe it's been passed by Idaho. It is law in Washington is that source of income is protected. I think it can come into your jurisdiction pretty easily. There's a case out of New York, out of Yonkers, New York, where a landlord refused to accept a housing choice voucher recipient years ago and was prosecuted under a disparate impact analysis for disability discrimination, and the plaintiff prevailed in that case. So I think there's a common law basis to bring that protected class status to your jurisdiction. But I think you've got a pretty well-informed audience.
And the other thing that I would point out is like ethnicity and gender, or no, ethnicity and age.
Age is the other that's not
Yeah,
protected class under the Fair Housing Act.
right. Under employment law, that would be something to look at. But you basically your 7 protected classes are race, color, religion, gender, familial status, disability, and national origin. Okay, good deal.
Eric, you know, from working with me, I like to think outside the box a little bit when we talk about protected class status, and I get very concerned when I see people thinking that they don't have to give deference to a certain protected class status that hasn't been adopted yet. I've worked with both Northwest Fair Housing Alliance out of Spokane and Intermountain Fair Housing Council out of Idaho. I've worked a lot with Intermountain Fair Housing Council out of Idaho. I find them to be a very aggressive claim facilitator, and they're very active in their grant participation. I think that they are absolutely a group that could bring progressive theories of recovery to fair housing to Idaho, and we'll be looking for new theories of recovery down the road. So I don't put a whole lot of stock in what's protected now as opposed to what's going to be protected in the future. And I would encourage everybody here to be thinking in a open-minded fashion about who's protected and what's protected, because it doesn't take a whole lot of folks for you to be prosecuted for a fair housing violation, in my opinion.
Okay. All right. Well, thank you. Let's go ahead and get out of that. And I am going to share your presentation now. That's my hope anyway. Okay. So now,
Close the icon in the middle. Yeah.
tell me when you're ready to move.
Next slide, please. So my name's Eric Stephen. Can we go back? My name's Eric Stephen. I'm an attorney out of Spokane, Washington. I practice in all counties east of the Cascade Mountains in Washington and northern Idaho. I've been a lawyer for 30 years. My practice is focused on subsidized and affordable housing and manufactured housing communities, mobile home parks, as well as market rate housing, primarily multifamily. I essentially run an eviction mill. I also defend landlords charged with housing discrimination. I help write policy. David Penny will introduce himself when he gets to his next slide immediately following me. We're going to talk today about several different topics of fair housing, and we've tried to organize the presentation in a manner that kind of flows with your experience with tenants. So we're going to start with an overview of concepts and protected classes. David Penny will talk about a lot of fair housing concepts that are germane to the industry. Then we're going to talk about advertising properties. We're in a fair housing context. We're going to talk about tenant screening and what you can lawfully do in tenant screening, what you can't do. There's been a lot of development in tenant screening over the years. We're going to talk about developing non-discriminatory rules so you can have viable rules that are enforceable. We're going to then talk about enforcing those rules in a non-discriminatory manner, making sure that you're policing the tenants from engaging in conduct. I find that rule enforcement is a great opportunity for you to ensure that you insulate yourself from fair housing claims, but also can create fair housing claims if it's mismanaged. We're going to talk about protecting against discrimination, the policies and protocols that you have to be a housing provider in today's climate lawfully. And then we're going to talk about what to do when you find that some discrimination has occurred on your property. Try to avoid some of the knee-jerk reactions that happen in those situations and make sure you're in the best position to deal with discrimination that's been discovered and go forward in a proactive way with the least amount of liability exposure. So those are the concepts and topics we're going to talk today about. And I believe David Penny's going to talk now about concepts, an overview of concepts and protected classes.
Hello, everyone. Welcome to this presentation. I know some are probably eating lunch because we're over your noon hour. That's great. We're doing this as an intermediate class with the idea that most people have a basic or fundamental understanding of fair housing. So we're not going to try to exhaust every topic with instruction. We're going to try and build on what you already have as far as that knowledge. Usually I speak frequently on fair housing topics, but instead of an empty conference room like I have with me now, it's usually a room full of people. We get some energy going in the room. We get to smile, we get to frown, we get to ask questions and be interactive, and some energy build. So this is definitely going to be a new approach to fair housing. But like Eric, I was in private practice for a little over 30 years, and now I'm general counsel for Tomlinson and Associates, and have had the benefit of not only seeing fair housing from a lawyer standpoint, but also an operations standpoint. And again, it's just solidified in my mind how important this is. And I believe you're going to get a lot out of our presentation today. So Eric, let's go ahead and move on to the next slide. Okay, so why is civil rights important, or fair housing important? And it's important because it's about civil rights. The fair housing laws are really a group of laws. We think of the Fair Housing Act under the federal law, but there's state law, local laws that in general prohibit housing discrimination. We're going to get into those in a minute. But the elevator speech about what is fair housing is that it's illegal to treat a person differently in a housing transaction because the person is a member of a protected class. We had our first question about protected class and who is a protected class. That's obviously key to this. And then a housing transaction, we're going to talk about those. It can be renting, selling, lending, advertising. But it's all about equal access for everyone, for all, to the housing, so that protected class status doesn't disadvantage someone in that access. Next slide. So here again, why make it a priority? It's the law. Real quickly, in 1968, the Civil Rights Act of 1968 was signed into law by Lyndon Johnson, President Lyndon Johnson, and it was 1 week after the assassination of Martin Luther King. Title 8 of the Civil Rights Act of 1968 is the first Fair Housing Act, and has a lot of what we're going to talk about today. It was those base groups: race, religion, color, sex, national origin, protected. Those were the protected classes originally. In 1988, Ronald Reagan signed into law the amendments to the Fair Housing Act, which added familial status and added disability to the protected classes, as well as some other changes. But that's really the important part of it. Interestingly enough, I'll jump right to a jewel that may be important to everybody here, and that's that the definition of sex as one of the protected classes has likely changed, and changed as of June of this year. The U.S. Supreme Court, in the case of Bostick versus Clayton County, it was an employment case under Title VII of the Civil Rights Act of 1964, the very first Civil Rights Act. But the question was the definition of sex. And in that case, the court held that, at least in the employment context, that sexual discrimination included discrimination based upon sexual orientation, gender identity, and expression. Well, sex is used in that act the same way the word sex is used in Title VIII of the Civil Rights Act of 1968. So very possibly, we have just had the definition of sex expanded to where it would include those. So Eric was talking about thinking outside the box. There's not a case right now saying the word sex under Title VIII means what I just explained. But by extrapolation, you can pretty well get there. That it's not going to be defined one way under Title VII of one Civil Rights Act and defined differently under Title VIII of another. So the law, Idaho has its anti-discrimination statutes, which are found at Idaho Code Section 67-5909, the act that sets up the Idaho Human Rights Commission, which is charged with the responsibility for enforcing those laws. The Idaho fair housing, or the fair housing statutes, are a little bit different. They follow the federal law, same types of real estate transactions. They do not mention familial status as a protected class under Idaho's laws. And the Idaho Human Rights Commission is rarely called on to enforce those. Almost all enforcement of Idaho is at the federal level because Idaho has not achieved what's called substantial equivalency. Idaho doesn't have an enforcement mechanism that equals the federal mechanism, and therefore Idaho complaints are referred to the federal agency HUD for enforcement as opposed to being done locally. I think Eric can certainly let us know, but I think Washington does have equivalency. And so there, if you filed a housing discrimination complaint in Washington, a Washington agency would investigate it.
Washington, I believe, on assistance animal claims.
Yeah. So the other law to be aware of is local laws in Idaho and ordinances found in many cities, such as the city of Boise. I think there's 7 or 8. Any significant population has an ordinance that makes it a crime to engage in discrimination based upon sexual orientation or gender identity. And so even if you were to say, well, I'm not going to extrapolate from the definition of sex under to the Fair Housing Act or Idaho law, you still have to be cognizant of the fact that you could be providing housing services in a municipality's jurisdiction where they have actually a criminal ordinance that says you cannot discriminate on that basis or you violate the law. Non-compliance equals a denial of civil rights. And so that implicates enforcement by such agencies as the Department of Justice, that towards the end we'll talk about enforcement. It's a serious matter. And if the federal government gets involved, it becomes really serious. Go ahead, Eric.
I just wanted to interject something. I had a case years ago where a landlord had been charged with discrimination based on an assistant manager's conduct. The assistant manager was arrested for felony extortion, and she and a couple of her compatriots that had approached the manager compelled the manager to resign, or tried to compel the manager to resign. Anyways, it was a case where I didn't think the claimant had a very good case at all. The case went on for, originally we got a no cause finding in the administrative investigation. A year and a half later, HUD hired a new executive director, opened up the case, or actually 6 months later, they opened up the case. We got our no cause finding reversed a year later. We went to a jury trial 5 years later, and then went to the Court of Appeals 7 years later. And then the complainants tried to get certiorari to go to the Supreme Court 9 years after the case started. And I think that just is a little bit of illustration of the expense of some of these claims if they go wild. Most of them aren't like that, but they have that type of potential. I was lead counsel of 3 law offices in that case that went on for essentially 7 to 9 years, you know. So they can be quite expensive, as David said.
Yeah, even the simplest one can be tens of thousands of dollars. And then you get into something like Eric was just telling us about, and you're into the hundreds of thousands of dollars. The bottom line is taking resources out of your business, taking resources out of your property. And so there's a good reason to avoid this type of litigation and these types of disputes. Okay, so we talked about protected classes, and we say that this is all about equal access in real estate transactions. So what are some of the discriminatory actions? First, refusing to rent, sell, or finance housing, you know, just a flat out refusal. It can be telling somebody no verbally who's trying to buy, or it can be more subtle than that. It can be making yourself unavailable, or steering them or sending them somewhere else, or setting some criteria or requirement that they can't meet. The other, refusing to give information, discouraging people from renting or lying about availability. This can be as simple as a manager getting a phone call from one person who has very proper English, no accent, and gives them one set of information. And then the manager, an hour later, gets a call from someone who has a thick accent, maybe is stumbling, having difficult with English, and doesn't give them the same information. That could be the difference in refusing to give information based upon protected class. Applying different rules, privileges, standards, or qualifications. We're going to go into this later in more detail about drafting rules and enforcing rules. But if you're enforcing rules in one respect against a family that you don't enforce against adults without children, then that's a disparate impact perhaps in the treatment of individuals. Evictions and providing of services, the same. If your eviction policies, who you take to eviction quicker is based upon some protected class factor, then that could be a problem for you. Making discriminatory statements. We're going to talk a lot about advertising and marketing, but it can be the manager walking the property. It can be at that level. A lot of these things that can be mistakes are verbal. Some of them, though, can be in your newsletter. They can be in your advertisement. They can be in your rules. So, and we're going to get into that in quite a bit of detail. Next slide. There we go. Okay, steering. That's probably a word most of you have heard. And then steering in its most basic form is probably best illustrated by an example. You've got 3 buildings at your apartment complex. The building C is closest to the playground. So the families, you show families in building C apartments where you have apartments that they might want in building A or building B that are available. That could be steering. It could do it based upon, I know at times have been the assumption that people of certain backgrounds want to live together. And based upon that, a manager believing that they're doing a great service takes everybody of that ethnic background and steers them to a certain property or to a certain building. So when we talk about steering, that's what we're talking about. You're denying choice to these people because you're not making all the availability available to them. Yeah, Eric.
Those are great examples of steering, David. We had one in Spokane where a well-intentioned landlord was trying to dissuade families from applying from filling units on the second floor of a multifamily complex because they thought the balcony was a hazard for children. And I think a lot of times steering is well intended by the landlord, but it just can't happen and it's wrong. You've got a duty to make the property safe and then let the applicants choose which unit they want.
Yeah, I've actually seen that exact same case. So that's a good example and one that predominates where the landlord thinks they're being careful and looking after the applicant or resident's children by directing them away from an apartment, where really the answer is fix the railing, fix the stairs, and offer it to everybody. Harassing, intimidating, threatening, or coercing. This gets back to what people say and what they do. And I think these kind of speak for themselves, but I'd also mention that if it's tenant versus tenant, people tend to think, well, that's not me as the manager, and that's them. We're not the police, so we're not going to sort that out. Well, I wish it was that simple, but it's not. And that you have to pay attention to harassment or threatening of tenant versus tenant. And we're going to get into investigating cases and rule enforcement. And one of the things you have to do is if there are allegations between two households and you have he said, she said, or the like, you got to talk to both sides. If you just talk to the Caucasian household and don't go interview the African-American household to the controversy, or interview the family and don't interview the other side, then you're treating people different. So in handling these, you can't turn a blind eye. You can't let somebody harassing, intimidating, or threatening another household because of their protected class status and turn a blind eye to that. You have an obligation to enforce your rules. Everybody's rules prohibit this conduct. And so you have to enforce that for the protection of everybody against and for everybody equally. Yes, Eric.
Before we go on, I think your example of tenant-on-tenant harassment is very good, David. I see that a lot. We have a protocol through our Washington State Human Rights Commission where we investigate, like you talked about, David. We are supposed to refer the parties to mediation to mediate their disputes among each other. And then we're supposed to take action if we can determine which party is actually discriminating or harassing based on discriminatory animus. And it's interesting in Washington, at least, the case law that I'm aware of is that if you take action to evict both sets of tenants, that can be discriminatory. So tenant-on-tenant harassment is a really loaded situation in my experience, and it's one that we see a lot, and it's really difficult to navigate through at times.
Yeah, and so that's probably one we're going to get questions about later on, and we're certainly willing to take those because it's one of the most difficult areas for site managers. You feel like you're put right there in the middle, and one of the things I'm sure you'll hear from Eric too is document, document, document. And you're gonna hear that throughout the presentation today. So the other is refusing to let a person with a disability make modifications necessary to use the dwelling. That's a simplified definition. Person with a disability, there's a nexus between the modification they're seeking and the use of the dwelling. All that should sound familiar. So that would be a discriminatory act based upon disability. And we're going to talk quite a bit about that. Then the last one, of course, requests for accommodations. We know that those are changes in rules, policies, practices, procedures, lease terms that a person with a disability needs so that they can have equal use and enjoyment of the dwelling that they lease. And we're going to go into when you're required to make those accommodations and when you're not in the various settings. And, also we're going to talk about some guidance that came out in January of this year, which gave us a lot of insight, not just on, it's predominantly about animals, but it gives us insight, not just about animals, and requests for accommodation for animals, but all requests for accommodation. We're going to bore down on that. I think you'll find that interesting. Next slide. Okay, well, we're going to bore down on a little bit next, I guess. And so we're not going to try and cover talk about every class. We're not going to bore down on race or color discrimination right at this point because of time limitations. I think we all know those, and there'll be examples we'll give, but the discrimination cases that Eric and I are seeing and the complaints that are being filed against clients chiefly arise from disability discrimination allegations and familial status discrimination allegations. Those are the two dominant ones today in the current climate. So we're going to focus on those out of the chute. Here, the one note is that when we talk about making modifications to apartments or apartment complexes for people with disabilities, we'll be talking about Section 504 of a separate act. It's not 504 of the Fair Housing Act, but it basically, the distinction there to remember, it has almost the same requirements of the Fair Housing Act, except for that if you were in publicly funded housing, HUD project-based or RD housing, under Section 504, the housing provider pays the reasonable costs of a modification, whereas in conventional housing or non-publicly funded housing, that expense falls to the resident or applicant. So that's the reference to 504.
That's the Rehabilitation Act, isn't it, David?
Yeah, of 73. I think it's Rehabilitation Act of 1973 is what that is. Anyway, and then also we got to compartmentalize ADA, because you'll hear people mix ADA in with Fair Housing Act. And basically ADA are the public areas up to the threshold of the apartments. It's your clubhouse, it's your leasing or rental office primarily, are going to be areas where the ADA applies. And ADA has a very different criteria. There's been recent guidance with the ADA as well, in that ADA is very different from the Fair Housing Act, because ADA gives rights to those people who have service animals. That's that, and it's pretty much got to be a dog, although there's a very narrow exception for miniature horses. But anyway, it pretty much has to be a dog that's been trained to do something for a service because the person has a disability. For our purposes, the thing to keep in mind, though, is if you are dealing with people applying for housing or who are residents, then you have to allow them to bring their animal under the Fair Housing Act with them to come see you at the office, to come utilize the clubhouse, because it's still part of housing. It's part of your apartment complex, and they need that animal. So I think for the housing provider in general, you don't need to be distracted with the ADA. It really isn't going to change how you treat people who need the animals. So I think it may make a difference for somebody who's not an applicant, not a resident, is coming off the street to attend an event at your clubhouse. Do you have to let them bring a pure comfort animal or emotional support animal in? Probably not, but most of us aren't dealing with that circumstance. So I think we can look at it from the standpoint of a housing provider under the Fair Housing Act. Okay, next slide. Okay, so, these are just some key points that we're trying to get up, people thinking about them, general rules. I think most of us should know this, that when working with an applicant or with a resident, you cannot ask them about the nature or identity of their disability. You can only ask the same questions that you would ask of all other applicants. On this, there is a tiny exception. If you are a provider of housing that has a special benefit to offer for somebody with a disability, a purely adapted unit for their use, you can ask whether they would need that type of a unit, but that's the only exception. Then the other is confidentiality. I think most people should or do have a system in place to keep that information confidential. The biggest example I would give there is the manager's out walking the property and has allowed Jane in apartment 101 to have a comfort animal because of correctly processed a request for accommodation. Joe in 201 was denied having a pet. And so he confronts the manager on the property and says, well, why did you let Jane? Why does she have an animal and I don't? And the manager says, it's because she has a disability, or it's because she has emotional problems. You've just breached confidentiality with the person whose request for accommodation. The correct answer to Joe is we apply our rules the same to everybody. That's the answer. And that's the reason, and leave it at that. So then the last one here, some tenants with disabilities may have special needs requiring accommodation or modification. Of course, we're going to get into that. So we can go to the next slide. Okay, so just one more thing about request for accommodation and modification. We have a whole section in that we're going to get to under our heading of rules and rule enforcement, because what is a request for an accommodation? It's usually to modify some rule, policy, or procedure. And so it ties in with rule enforcement. That's where we're going to address it in conjunction with the guidance from January of this year. So then, familial status, what does it mean? It's a household that has one or more children under the age of 18. And they can be living with a parent, step parent, legal custodian, or designee. The child can be an expected child through pregnancy, adoption, or perhaps even a custody proceeding in court. So under all those, either a child in the home or adults who are working or should soon have custody of such a child. Next slide. Does this mean that a landlord must rent to or cannot evict a household with children? No. What we're talking about is you have to give equal access. You can't disadvantage a household because they have children or treat them differently. We're going to talk about tenant screening in great detail. And as this slide makes clear, you can always use acceptable objective criteria, credit history, tenant history, criminal background, and such things to screen tenants. You just can't make it because they have children in the household and you just repainted and recarpeted the unit and you're like, God, if there are kids in there, it's going to be bad. You can't do that. that would be discrimination. Next slide. And here again, this slide brings up the issue of steering. And it was one of the examples we talked about. You know, we just rehabbed building A, building B hasn't been touched in 30 years. So let's put the families with children in building B because we know they're tough on a property. That would be discrimination and steering. Eric.
Have you seen the situation where the landlord has the moonlight worker that has the bottom unit, and then you get the family that moves up above, and then they cause all sorts of ruckus during the daytime when the tenant down below's sleeping, and then you end up evicting the unit above, and then you go to lease up the new unit, the unit upstairs again, and lo and behold, here comes a family of 5, and they're qualified. Can you tell those people, hey, it's just not going to be a good fit because George downstairs sleeps during the day?
No, I don't think you can preemptively judge whether a family and their kids are going to be, like the last one. So I don't think you could steer on that basis, on the noise that the children are going to generate. Here again, noise is noise, whether it comes from children or adults with heavy feet and big voices and bad language. So, and whether it's music being played at 2 a.m. or kids playing basketball in the living room at 2 a.m. So I think you just have to judge it for what it is. And on this one, try and be an umpire. Those are difficult situations. You had mentioned mediation before. Here, I think that's where the manager is acting as a mediator, trying to figure it out. Of course, the best solution may be not to worry about the family as much as they're another unit that would better suit for the person that works the night shift, and put them in a different area. Next slide. Occupancy standards we're going to talk about this too in screening, but that's one of the biggest areas where familial status becomes an issue. We're going to talk a little bit about how, and I think Eric's going to jump in on the Keating memo, which was a HUD document that basically had the presumption of 2 persons per bedroom. And that's become an occupancy standard by default. But it's not the end to an analysis. If that's all you're doing and saying no more than 2 persons per bedroom, you're not in a safe harbor or protected against a claim that your occupancy standard is discriminatory. Very often what you're seeing now are standards of 2 per bedroom plus an additional individual, or an additional individual up to a certain age that goes beyond that. And I don't want to step on Eric's toes because I know Keating memo was something he was going to talk about. So I'll turn it up to him to jump in on this.
Well, Dave correctly described the Keating memo. It was an internal document created by a person named Keating. And originally it was deemed sort of the law of the land. 2 per bedroom plus 1 was deemed to be a viable occupancy standard. My experience in occupancy standard and housing discrimination is that it's very tough for the investigators. The investigators don't have real good rigid tools to gauge occupancy standards. There's uniform business or uniform building code that they can look back to. They can look at local fire codes. But my experience has been that the investigators really struggle with occupancy standard cases. There's a case called United States of America versus PATH that came out in 1995, and our U.S. Supreme Court just pounded HUD in the dicta of the case, talking about how dare you have these generic laws, thou shall not discriminate, and then run around with this big stick just thumping the hell out of everybody that violates it. And in the United States of PAF versus United States of America case, the court upheld a legitimate occupancy restriction because the building, the leasehold system, it was a single family residence dwelling, and they found that the systems of the dwelling, the plumbing systems, some of the other systems, were not able to sustain the load that was posed by the family or the individuals that were in occupancy there. So there's some safe harbor on that. It's funny because Keating, the originator of the Keating memo, the 2 per bedroom plus 1, he ended up retracting that statement later on. About 5-7 years ago, he wrote something out that, hey, this is supposed to be an internal message. It wasn't supposed to be the law of the land. Really wanted to have something outside of that that was more case specific. And I think HUD is now looking at these cases, hopefully with a little more sort of ad hoc case by case analysis. But occupancy standards are really tough. They invite familial status as well as national origin claims, in my opinion. I struggle with these cases. I know the investigators struggle with these cases, and there's just not any firm ground on occupancy. I think Keating is still the law of the land for the most part, 2 per bedroom plus 1, but really tough cases.
Yeah, I would just add to that a couple of things. One, that under, I think the Keating memo mentions it too, that if somebody has a loft or like had a separate office room, that has to be considered as another bedroom. And then the other thing that I would say, that your big and most important thing here is have written occupancy standards in place. You should have something in writing that is based upon the square footage of your units, the number of bedrooms. It would be good to consult with an attorney that is learned in such things as occupancy standards to look at it and say, well, what would be reasonable? What would be defensible if I ever had to defend it? So, you know, there's two. One is providing housing for families without discrimination. The other is wear and tear on the attributes and facilities within an apartment, your housing, your facilities, and having some control. And I saw a question, 2 per bedroom plus 1 for each bedroom unit. No, it'd be 2 per bedroom and then plus 1 additional person in the apartment. That could be a occupancy standard someone might look at. We're not saying that is the occupancy standard you should use. It is one that is becoming more and more prevalent, but it's 2 per bedroom plus 1 additional person in the apartment.
Let me interject here too. HUD will not consider a really young minor child to be an individual. So if you have a newborn infant that's sleeping with mom and dad or mom or something like that, real easy for HUD to bypass that and say that's not count that infant as a body in the computation. Also, the Uniform Building Code has a formula, kind of like David was talking about, where they look at the common areas and look at the kitchen common areas and some of the other common areas of the building, the dwelling, and take those into consideration. So you may not have enough bedrooms, but you may have a big enough residence or dwelling that would allow for more than the bedroom count or the Keating count would allow.
So, and just another thing that popped to mind as Eric was speaking is you don't count a child that's in utero. You don't, a woman who's pregnant, you don't count the child that she anticipates in deciding on persons per bedroom, for example. So the pregnant gal gets familial status coverage, but you don't count the kid, right, Dave? Right. That's the way, yes. So to keep moving along here, just under this overview, a few more slides. Let's go to the next slide, Eric.
Okay, before we do that, I'm going to pop in as my role, in my role as timekeeper, and we are at the 1 hour mark, guys, and we're not quite through section 1. I just wanted to give you that feedback. And then Eric, if you, the closer you get to your microphone, it gets a little bit muddy. So maybe, yeah, about there is good. All right, so I'm gonna go to the next slide.
Okay, I'll just talk faster. Okay, so real quickly, can a landlord discriminate against people who do not speak English? Everyone, I'm sure I heard it somewhere out there, this big, no, you can't do that. Some people will have heard of LEP, limited English proficiency, and the requirements of some properties. And we're going to talk about those a little bit later. But one of the things to definitely understand is whether LEP applies to you or not. And it applies to the subsidized project-based HUD and RD properties. But if you're even in a conventional property, you still cannot let language or someone's failure to speak English become a barrier that isolates them from access to housing. You can't say, well, and this has been their cases on this, come back when you learn English. That would be a discriminatory step, or hanging up on someone that you can't understand. The bottom line is you have to try. If a person shows up to look for an apartment and they have an interpreter with them, you can't say, I don't have time for this, or I'm not going to, go through this. It's too difficult. That would be it'd be national origin discrimination is how it usually comes up and is usually prosecuted. So then the other thing are victims of domestic violence. That we just want to cover this quickly. This is a cutting area. People have heard of VAWA. It's a separate, it involves domestic violent victims. So it's important and it's relevant, and everybody except for pure conventional housing has to comply with VAWA. But separate and apart from VAWA is discrimination against domestic violence victims is sex discrimination, because domestic violence occurs with women far more frequently being the victims. And
Eric, we're on the next slide.
We're going to talk about this in a little more detail. Heard about that we have disparate treatment of people, which is, the manager won't rent to a family or something like that. It's an overt act towards somebody that's disparate treatment. And we've heard about disparate impact. And this is a disparate impact analysis under sex for domestic violence victims. Because the rule against violence, you might have a rule that says, people fighting each other in the apartment, maybe against damage to the apartment, loud voices causing disturbances violate the lease. And that's neutral on its face. And so you say, well, what's wrong with that rule? Well, you can have that rule and it's fine. But if you apply that equally across the board, then you could, and so that there's a disturbance in an apartment, to keep it simple, husband and wife, and there is, and she's the victim, but they're both yelling, shoving, whatever, and you evict the household, evict both of them, you're going to be evicting women victims of domestic violence at a higher rate than you would men. So you have to be cognizant of this. And when you've got to look, you can get down to the investigation of enforcing your rule. You've got to investigate it. What went on? And determine if there was one's a victim and one's the perpetrator, then the one that's the victim shouldn't be treated the same as the one that was the perpetrator. Eric?
I don't ever evict for domestic violence. I usually evict for assault, and then and I evict for noise, and I evict for other types of conduct, but I really stay away from characterizing tenant conduct as domestic violence. because of the dynamics that you're discussing. So I think you got to separate who's a perpetrator, who's a victim, and be real clear in that. You don't want to, I think anytime you're issuing comply or vacate notices or any other type of notice and you're making an allegation of domestic violence, I think that's a bad move. I always issue those notices for screaming and yelling. I wait to find out who the perpetrator is and then take action against the perpetrator when I can figure that out.
Yeah. So this is one of those tough areas for managers. And then finally, let's go to the next slide. In the interest of moving on to other topics, I'm just going to be very quick here, and we talked about this before, but I mean the penalties for violating fair housing laws up to $50,000. That doesn't even involve the civil liability and lawsuit and attorney's fees. And so very good reason for us to be having this discussion today. With that, I'm going to turn it over to Eric to jump in and take us into advertising and marketing.
Okay, thank you very much, David. Now we're going to talk about advertising and marketing. Let's cue the next two slides. Next. So Section 3604 of the Fair Housing Act makes it illegal to make, print, publish, or cause to be made, printed, or published a statement or advertising related to the sale or rental of a dwelling that indicates a preference, a limitation, or discrimination based on race, color, religion, sex, handicap, status, familial status, national origin, or intention to make such preference or limitation. The liability extends to both the person that placed the ad as well as the publisher of the ad. And generally, you want the housing advertisements to describe the property, not the potential occupant. Let's go to the next slide. You need to avoid advertising that uses certain words or phrases or pictures, like photos with all Caucasian folks in it, or photos with all folks of a specific ethnicity in it. That would be a picture that might be a visual representation that is deemed discriminatory. You need to avoid using certain types of media or means of discrimination that are solely focused on one type of protected class. If you did all of your advertising in Ebony magazine or something like that, you might be discriminating because you're targeting a specific protected class status. Even if it's to include those people, that could be discrimination. So you need to avoid code words or catchphrases that could come into play. Avoid using color preferences like a white community or all black community. That would be a discriminatory advertising. In familial status context, if you advertise for singles only, I see that in a lot of the college towns, that can be familial status discrimination. Or if you advertise for married couples only, that would constitute familial status discrimination potentially, even though marital status isn't necessarily a protected class. On handicap status, you can't advertise saying property not suited for handicap. Inclusion of accessibility and handicap or disability status is okay. So you can say handicap accessible or disability accessible, that would be fine. You can't use national origin in discriminatory advertising. You can't express a preference to Italian community or Hispanic community, or Caucasian community. Race is prohibited in advertising. You couldn't say that we prefer an Asian community or this is an Asian community. Religious discrimination can occur in advertising if you say Catholic community, Christian community, Jewish community, housing for Jewish people, that type of thing could get you into hot water for discriminatory advertising. And expressing a gender preference, except for when there's an intimate shared space relationship. So there's been an expansion of the law with respect to sex and gender discrimination as it relates to shared facilities. And you're seeing more and more, especially in these college towns, housing where the dwelling is divided up into bedrooms. And in those situations, there's a roommates.com case that talks about how the intimate shared space relationship of these dwellings dictates that the roommate should be able to express a preference for somebody of a specific gender, but the landlord can't necessarily express that preference. And you could rent a single family dwelling as a landlord and say, I'm looking for a clean female occupant to be a tenant. So that would be an example of gender or sex discrimination in advertising. Let's go to the next slide. David, do you have anything?
I was just going to say that, one of the examples would be if you have a house and you're advertising for a tenant to rent a room in your house, then obviously everything Eric has talked about applies. On the other hand, if I have a house and I'm looking for someone to share the entire house with me, be my housemate, or I have a room and I'm looking for someone, I have a single room, I'm looking for somebody to be my roommate and share that room, then specifically with regard to gender, you can express a preference.
Thank you, David. Somebody talked about HOPA housing. We're going to get to that. You can have an expression of preference to housing for older people, and we'll talk about that as we go on. Let's go to the next slide. Any photos, drawings, symbols that may imply a preference to a specific category are prohibited. Putting a cross on your advertising or a Jewish star on your advertising would be expressing a preference to a protected class. Describing the location by using potentially biased references near the synagogue, near the Catholic Church, those are preference issues. A reference to a discriminatory facility known to be notorious to be discriminatory is prohibited. If you said near the XYZ Country Club or the dwelling units near the XYZ Country Club, and XYZ Country Club was notorious for a discriminatory element, maybe it's a place where the Klan meets or something along those lines, that might be discriminatory advertising. You need to avoid using welcoming and inclusive terms such as advertising that specific groups are welcome. And that goes back to like my Asian community type of comment. You can express a preference for HOPA housing, which is senior housing. We're going to talk about that. I see a couple questions flashing up. I think we need to wait for questions till the end, guys. We're so far behind, but what HUD wants you to use is their logo and their fair housing principles that we follow the fair housing guidelines. That's your message that we're inclusive and not discriminatory. Let's go to the next slide. Here it is, folks. Here's your HOPA housing. Housing communities for 55 and older or 55 plus housing. 80% of the units must be occupied by at least one person 55 years or older. There's an annual audit for this to make sure everybody is maintaining at least one household or one occupant 55 years and older. There's also 62 years and older housing. All occupants must be over the age 62. HUD wants you to advertise these communities as senior housing or 55 and older community or 62 plus community. They do not want you to use terms such as adult community. Let's go to the next slide. This is yours, David.
Okay. Yeah, so just kind of a summary with regard to marketing, maybe more than advertising. So marketing expands beyond that. In your office and in your rental office, it's the law, actually. You need to be displaying the current fair housing posters that HUD has. There's one poster in English, one poster in Spanish. There's a regulation under HUD requires you to have those up on the wall, and you should. Post your fair housing policy. And that policy is just a general statement of inclusiveness and equal access for all. There's no magic language to it, but those are the two general themes. Making sure your advertising is fair housing compliant. Eric just went over that. Basically, advertise the attributes and amenities of the property. Don't advertise who you're looking for as a resident. You can talk about the clubhouse, the pool, the exercise room, the playground, the open space, the available parking, everything like that. Certainly rents, included utilities. Let those be or location in a non-discriminatory way. Let those be what sell the property. Just a good solid rule of thumb is don't describe who you're looking for as a resident. I mean, young and vibrant might be a problem because most people with disabilities may not see themselves as young and vibrant individuals or parents who are pushed because they've got young kids. Anyway, it's all about what you offer. And then lastly, marketing. This kind of relates back to steering. Don't make assumptions about what an applicant may want or may not want based upon what a family might want or what you think people of a certain ethnicity might want, or somebody with a disability might want. When you start making assumptions about people, that's when you're really run into the problems. Make it all available to everybody. Show all the units that you have that they're interested in. Don't assume what may or may not be the object of their search. I'll just mention in one sentence, there's an interesting Ninth Circuit court case against roommates.com. And one of the roommates.com, the problem they had is they would, using their search engines and their filters, would ask questions and lead people to available housing, restricting what they looked at. And some of the questions and some of the filters were questionable whether they were discriminatory. The Ninth Circuit said that a lawsuit could be maintained against roommates.com. I don't think they came out and said what was or wasn't whether it was actual a violation or not, but they said that a lawsuit could be maintained against roommates.com. This is a question, if we could just have a brief time out with Eric Stevens and Eric Kingston, and that's with, given the number of questions we have and where we are in the materials, whether we should divide what we're going to cover between this session and next week's session, and as opposed to plowing through. I mean, I know our plan is to try and plow through to the end. I'm open to doing it either way, but we have tenant screening coming up, which we'll probably spend some time on. And so I just throw that out there. I can go either way.
Yeah, that sort of occurred to me as well, David. Assuming people have the time to sign up for, kind of maybe the second half of this next Tuesday, same time. And we'll, I think we've got the links to send out to everybody. That might be a good move so that you can cover things in the detail you need.
Yeah.
I've got Jamie says it sounds good to her. So
in the remaining time, or we could take questions now. And I can do either, but I just thought that might be an option. I'm good. I keep seeing comments. That sounds good to me.
Okay.
Questions that we want to field then?
Do you want to just do tenant screening and then ask some questions?
Well, I'm just saying we can take some questions now if we're going to slow down and just try to bifurcate the presentation.
Sure. What, Eric, do you want to, I mean, people obviously have them, so do you want to field a couple and throw them out there for us?
Sure, you bet. We did have a question about, the 55 and older properties, and I think, Eric, you kind of addressed that. And then somebody asking about documenting efforts to provide translation or interpretation, which are both different. And how to document that.
David and I are both on the same page that you win fair housing cases with documents and exculpatory evidence. I'm a big fan of documentation. I believe your documents work as a sword and a shield. They work as a sword because they allow you to take affirmative relief against people and they work as a shield because they provide exculpatory evidence as long as your documents are lawful. So when you have somebody that has English as a second language, and it's obvious and clear that they are not communicating, the general inclination is to use their family members to translate or interpret documents. Really, HUD doesn't want you to do that. David Penny touched on the fact that affordable housing providers are frequently required to have a language assessment plan, an LAP policy, as well as a limited English proficiency policy when they identify that there's a substantial portion of their tenant composition that speaks a specific language as their first language other than English. I believe that concentration is probably about 10 to 15%. I have a lot of clients in Washington State that are providing interpreters and translators. I believe that in the subsidized side, the owner provider has to provide those services. I think in the market rate side, it's probably for the tenant. But I believe that LAP is language assessment plan. LAP, language assessment plan. That's to determine whether or not your limited English proficiency policy has been triggered. So two different policies. The LAP is to decide whether or not you have to implement the LEP. But I think that in a market rate context, you can get into a situation where you might have to, as the owner, provide translation or interpreting services, depending on the concentration. And I think it's going to be a trend that we're going to see more of down the road. And I like David's example when he said, you can't just, hey, no habla inglés here. That doesn't fly, or come back when you speak my language. Those are the type of offensive statements that I think are going to come back and bite in the butt one way or another.
And then
if there are people out there that have a number of properties, or even one property, but certainly when we hear about LEP and LAP plan, and some of this is sounding foreign to you, and you have in your portfolio a HUD project-based property or an RD property, you need to really pay attention to that. There's somebody who's attending as watching our slide, Gary Haynes, who LEP is his bailiwick and his specialty. And I believe there may be information on the Idaho Housing Finance Association website in reference to Mr. Haynes. If not, I'm sure Eric Kingston can help you get that information and talk to him about what assistance he can provide. And then there's also, as we all know, there's great information on the internet, but Gary Haynes would certainly, at the fairhousingforum.org has Gary Haynes' contact information. And I've talked, it's a whole different subject. We could spend 2 hours just on LEP. So it's, outside the scope, although it's relevant, but I've never met anybody who knows more about LEP than Gary Haynes. So
I saw Gary had a comment, David. Gary had a comment that the age of the interpreter is not necessarily relevant, that there hasn't been that competency, I think, is the standard, not age. And then there was another question about what are the ramifications of using somebody that wouldn't meet HUD's guidelines for being a competent interpreter or translator. I think Gary's probably a good resource on this. I believe that the consequences would be that you'd be opening the door to a fair housing complaint, finding of cause, because you didn't properly navigate through the language barriers that were presented, and are then getting a national origin discrimination.
Yeah, I think, two things. One, under LEP, I think that those requirements, because there the responsibility is on the housing provider to affirmatively go back and have the interpretation to have the translation and to provide those things. Whereas if you're looking at just under the Fair Housing Act, it's really more one of cooperation and being able to work with the applicant or the resident. Certainly there are some requirements, but I think it's an interesting topic for discussion that if you're not covered by LEP, you're a conventional housing, and somebody comes in, an applicant, an adult who doesn't speak English, but they have their 12-year-old child with them, and they say, here's my interpreter, or this child can, says, oh, I can do it. I mean, can you refuse that when the obligation, or do you try it? And then if you say that didn't work, try and help them solve it. I think it's an interesting area. Because if they bring their 12-year-old with them to do the interpreting and you refuse, then have you made language a barrier? So I think that's an interesting area.
Wouldn't you agree that as much as we want to talk about this and how HUD's preference is not to use family members, I'll bet if we talk to Gary, he'd tell you that it occurs all the time in the industry, and it's probably the most convenient manner of communicating. So it's a tough dilemma, as Gary would say. You're in a rock and a hard spot, and the convenience is to use the family member, but HUD doesn't want you to do that. I can assure you that it's happening in a pervasive manner across the country.
Let's switch it. I noticed one of the questions was about whether we were going to cover COVID-19, and it is in the title of the presentation. So I think for that person that perhaps we should switch gears a little bit and touch upon it. I'll give my thoughts on it, and then Eric can give his, because I think being a practitioner in Washington, you very well could have a different view on it. So COVID-19 comes up in the question of, is it a disability under the Fair Housing Act? And if so, or if not, how do you analyze it, and what do you do? COVID-19 is obviously a serious matter. It's serious for housing providers staffing their employees, maintenance going in to do maintenance calls, running your office, just all aspects of working with residents. And then it's very important for residents and for applicants, and how it impacts them and their households. And, at least in Idaho, we're seeing an uptick of cases. In my opinion, COVID-19 is not a disability under the Fair Housing Act. It is an illness that can be severe or difficult, but its temporal part, it's how long a person is sick with COVID, just doesn't lend itself to the definition. Certainly it can have debilitating effects or make someone sick, but so can food poisoning. And food poisoning is not a disability under the Fair Housing Act. But the difference here is, if a person has COVID and it damages some part of their body, that damage could very well be a disability. I think the most obvious thing we hear about is how COVID-19 impacts someone's respiratory system. We've heard about making someone's lungs like glass. Horrible thought. So what do they end up with? COPD or some other respiratory diagnosed disease that is a disability. And then, of course, that condition may be what has to be accommodated. but it's not the COPD that's being accommodated. It's some damage or disability caused by COPD that would qualify under the definition. So that, I thought about it long and hard, done a little bit of research. I'm unaware of any case on point, but that's my analysis right now. I'll turn it over to Eric Stevens to tell us what he thinks.
Well, I agree with you in part, David. Washington is a little different because we recognize temporary disability over here as well, and we opened up Pandora's box, for disability status. I really believe that about anybody anywhere can be disabled at some point in time if they really work at it hard enough or search hard enough. So I think you can be pretty creative to get into that classification of that protected class. We have a governor's proclamation 20-19.4 currently over in Washington that prohibits us from taking any action in Washington against a tenant because of their COVID status. So we have a real different situation over in Washington. We are hyper regulated. I looked at the CDC order today again, and I don't think the CDC order provides any insulation against eviction on the federal level for COVID, but I can tell you at the state level in Washington, you could not take action against somebody because of their COVID status. And we see that when somebody has the COVID virus and they're refusing to wear masks, they're ambulating in common areas and potentially putting other people at risk. I know that's a little different angle than we were looking at for this, as opposed to being protected from fair housing violations. But I think it kind of plays into the pandemic and what you need to know.
Yeah. You brought up the CDC order, and just so that everybody's clear on that, at least Idaho and Washington are very different. Idaho does not have any state moratorium in existence. Washington has what Eric Stevens just described in Washington. And so in Idaho, it is the CDC order. It's the only thing that would be considered a moratorium at this time. And for those of you who may not be familiar or want further explanation, it basically says that if a person presents a declaration signed under penalty of perjury that their income has been affected by the COVID-19 pandemic, and they've tried to do everything they could to avail themselves of any resources available to pay rent, they haven't been able to pay that, or they've paid whatever they could pay as far as rent, and if evicted, they would be homeless, then, and send that in a declaration to the landlord, then they cannot be evicted for non-payment of rent prior to December 31st of this year. So that places a heck of, from a resident or tenant standpoint, you have to educate yourself about the declaration. It has to be in proper form, and you have to present it to the landlord. You can present it at any step in the process. You can present it after you get a 3-day notice. You can present it if you're sued. You can present it after the landlord has a judgment in hand or a writ and is showing up with the sheriff, but it has to be presented. And then there's that protection. And really, the landlord doesn't have an opportunity to test the validity of the statements in that declaration. Yeah, Eric.
A couple things here. One, I have heard of an Idaho attorney that had a case kicked out after examining the tenant defendant and being able to prove that the tenant defendant did not meet the declaration, the CDC declaration that was proffered. I was kind of surprised by that, but I have seen that. When the CDC order first came out, I really thought that the courts would be staying proceedings or staying the execution of writs of restitution until after December 31st. What I've seen across, or at least my experience on the cases and the relief that I've seen under the CDC order, is judges actually dismissing evictions saying that they didn't have standing because of the CDC order rather than stay in the eviction criteria. And then I just wanted to open up the door that the CDC order is really supposed to be about non-payment of rent. And it says that you can still evict for criminal activity that threatens the health and safety of other residents, damage or posing an immediate significant risk to damage to property, violating an applicable building code, health ordinance, or similar regulation for health and safety, or violating any other contractual obligation other than timely payment of rent or similar housing related payment, including non-payment of late fees or other fees. There was a question about how to navigate your accounts receivable in light of the CDC order and the inability to evict for non-payment of rent for somebody that meets the CDC requirements. In Washington, we are having to approach tenants with an invitation to repayment. We are offering an invitation for repayment. We're also having to provide them with a rent deferment agreement or a proposed payment plan. And our governor's proclamation has to be reasonable based on the tenant's individual health, financial, and other circumstances. So,
Eric Stevens, you just went mute.
What's that?
I can't hear you.
You can't hear me?
Now I did.
Okay, so in Washington, we are providing tenants that owe money after February 29th with an invitation for repayment and either a rent deferment agreement or a repayment plan agreement. And those are conditions precedent in Washington to us treating those debts as enforceable when the money's due after February 29th. When the question was posed about how to control your accounts receivable, the CDC order says that none of the financial obligations are discharged by the tenant. They remain viable. So you may want to use those type of invitation for repayment and repayment plans as a tool to control your accounts receivable.
I also, I guess this is a little bit of a pitch for IHFA in that they have received federal funds that are available to help tenants in conventional and Section 42 housing. Doesn't apply to tenants in RD or Section 8 project-based, or I think if they receive a voucher, they're not eligible. But otherwise, Section 42 and conventional, you can contact IHFA, and they have been instrumental. I've seen it firsthand of how IHFA has helped residents stay in their units, get landlords paid. Some of it is retroactive back, some of it is forward. And so there is help out there that's available. And I just encourage anybody who's a landlord that if you have Section 42 or conventional and someone's behind and they're telling you COVID's a factor, do what you can to get them in touch with IHFA. That's probably the best source of help.
I've put a link to that in the chat room chat also, David.
Okay.
David and Eric, did Boise get any CARES Act funding as well? The city of
I know with regard to properties they own. So New Path housing and some of the housing that's with the city, but I haven't, and this just might be my lack of knowledge, that I haven't heard of them having a money available like the IHFA program I described. So
might check with the individual municipalities. I know at least Spokane got several million, I believe.
So Eric,
Brady Ellis might still be on. Yeah, David, Brady Ellis might still be kind of listening in. So if he has any information, he could maybe type it in the chat room.
Okay. Any other questions? You want to pull another question for us, maybe on different topics, or?
Let's see. You guys touched on LEP and language quite a bit. Age of the interpreter. Documentation of same. a lot of the questions had to do with that. And the 55 and older, 55 plus, that was one. Oh, fair housing. Gary Haynes asked if you're going to cover fair housing and HOAs.
Well, a lot of what we've talked about certainly apply with HOAs. I mean, the big issue with HOAs is often rule enforcement, because we always know that there are CC&Rs that apply, plus there are often rules on top of that. And the Fair Housing Act applies equally to HOAs as it does to a housing provider renting an apartment complex. So a lot of this transfers over, and we'll certainly talk about it. Eric's going to jump in here in a second. I would say that now we've bifurcated this presentation. So next Tuesday, when we get into that rule enforcement, we'll be knee deep in HOA. Eric?
What I was going to say, David, is that HOAs, condos, they present an interesting dynamic frequently, because you end up with two relationships that I think, David, you were kind of alluding to frequently. One is the owner who is a member of the HOA or a condo association, and then you frequently have a situation where that owner goes ahead and then rents out the dwelling. So you have one situation where there's contractual privity between the owner and the HOA or the condo association. And then you have another relationship where there's contractual privity between the owner and the tenant resident in the unit. And then there's a failure to align the documents and the duties and the rights. And I think David's kind of alluding to that. Whereas the CC&Rs from the HOA or the condo association dictate the owner's conduct. But if those documents aren't made part of the relationship or aren't mirrored in the rules and the lease agreement or rental agreement with the tenant, who's the actual resident renting from the owner, you can get into a real dilemma there with respect to rule enforcement. And that's something that we can spend a little bit more time on next week. But I agree with David that almost everything we're telling you here is going to apply across the board to those other relationships and associations.
The one case I would mention I've seen is it was a subdivision of trailer houses, very nicely well kept. It was without attempting to meet any HOPA definition of over 55 or over 62. It was older folks, retired folks, living in these trailers, and they loved their community, and it was great. I'm sure the cribbage games in the clubhouse in the afternoons were fast and furious, but they didn't qualify as senior housing, but they had a rule against children. And one of the residents' daughter had health problems, and her grandchildren came to live with her. And so they were sending notices to this woman with her children that they couldn't stay there. And it violated some visiting policy or whatever, but it wasn't senior housing. So she had every right. They were discriminating against a family. And I believe in that. The HOA ended up paying money in damages. But the side note is it became so contentious and broke up the neighborhood. People aligned with each side and went back and forth that I'd be surprised if there's harmony's ever been restored. And so there's just a side consequence beyond that. But the same actions, the same considerations apply to HOAs as well.
David, I think that's a good segue to interject that HOPA housing has to be achieved organically. You can't force HOPA housing. You can't evict tenants that are non-compliant to get to the housing concentration that you're looking for. You can either start it at the beginning, or you can have it created homogeneously just through the process of that's how your community is sorted out. But you can't evict the tenants to get there. Now, once you achieve that HOPA housing standard, I think you can take action to enforce it from that point on, as long as you're documented and have it all across the board. And it sounds like the failure of the situation that you described was the failure to take the process the rest of the way to actually identify it as senior housing. Would you agree with that, David?
Yeah, they didn't. Yeah, I mean, they just had not met the criteria to establish themselves.
Do you think one household or something in that hypothetical failed to meet the criteria for age or something, and that just took them all outside the qualifications?
I just don't recall exactly what it was. It could have been a percentage requirement, but yeah, they just didn't. They didn't meet it with the Idaho moratorium.
I'm not sure of the Idaho moratorium.
Yeah, there's a question about the moratorium, and I had talked about a declaration, and that declaration you can find online. You just Google it, CDC resident declaration, and you can see what it requires. But yes, that has to be, it's the obligation is on the resident to sign and present that to the landlord. Until that time, they don't have protection under the CDC, and you can proceed with a eviction for non-payment. The key is that there are criminal penalties for if you get it wrong. So in other words, if they present you with that declaration, you stop, you slam on the brakes. The only thing you can do after that is give a reminder about rent, no more 3 days, and you don't take another step forward with an eviction. But until the point they deliver that declaration, then you can do whatever. You can proceed.
And David, that's a federal order, guys. That's not an Idaho moratorium. That's a federal moratorium. And like I said earlier on, I expected courts to be staying evictions, and what I'm really seeing is cases being dismissed. And like David said, you take the case forward, then all of a sudden you get dismissed. You're going to be out all those attorney fees and costs, and you may even be exposed to a negative award of attorney fees and costs in the eviction context, plus the liability exposure for violating the CDC if you push too hard.
Eric, you want to find us another question?
That is the most recent question we've got.
Okay.
Let me see.
In keeping with having accurate advertising, didn't you advertise this as also pertaining to lending?
Not in so many words, but it definitely includes that.
I can put in a plug for myself. I did a presentation for the Idaho Real Estate Commission that is on their website that deals with the topic of fair housing and real estate agents, primarily in the area of disability and what accommodations you make and don't make. So if there are any real estate agents with us or people interested in that topic, I direct you to that. Here again, it's a topic that's worthy of its own presentation. Of course, all the prohibitions against discrimination on protected class would apply. You can't treat people differently or deny them access to information or housing or opportunity because they're a member of a protected class. We had interesting discussions about you go to pick up a client, you're going to take them around and show them houses that they might be interested in buying, and they come out to your car and the person's 80-pound seeing eye German Shepherd jumps in the front seat with you. You know, as a real estate agent, do you have to work with that person, allow the dog in your car? Those type of considerations. I think just that example, the answer is yes, but I would just to let people know that resource is out there. Lending is another area that I think, I don't see it so much. I don't know if Eric Stevens has seen it a lot, but certainly on the national stage, big fair housing advocacy groups have taken the large banks and financing institutions to court and to task for violation of the Fair Housing Act, as well as other federal legislation, basically by creating a lending disadvantage for people of certain ethnicities or in certain neighborhoods, making it hard or more expensive to get a loan if you're in a Latino or an African American neighborhood than another neighborhood. And I know that it's been in the last few years, the US Supreme Court decided that the city of Miami could sue a bank, I think it was Bank of America, for predatory lending practices in Latino neighborhoods under the idea that the city was an aggrieved party and that a city actually sustained damage due to the conduct of the bank. So it's not just the borrower or the applicant for lending, for borrowing, that is adversely affected that can bring the suit, but actually the city can bring the suit claiming that they're an aggrieved party and have been damaged. So just to cover the waterfront, if you research fair housing cases, you will see a large number of lending cases that are fairly recent.
But isn't there a Fair Truth in Lending Act and then the Dodd-Frank Act are both probably indicated in that type of conversation?
I know there is other federal legislation. I've just focused what little bit I know on the Fair Housing Act, but yeah, defrauding people in lending transactions, I do believe has its own federal protection.
We do have another question, and it says, I may have missed the comments about evictions for reasons other than non-payment. If the tenant is current on rent, but the property is in shambles, can this issue be grounds for eviction, like a hoarding problem?
I have the CDC order right in front of me, and it says you can evict for engaging in criminal activity, threatening the health and safety of other residents, damaging or posing an immediate and significant risk to damaged property, violating an applicable building code, health ordinance, or similar regulation relating to health and safety, or violating any other contractual obligation other than timely payment of rent. So the CDC order does allow evictions for cause. I think the bigger question is, can you terminate a tenancy with a, I think it's your IC-55, 30-day notice to terminate a month-to-month periodic tenancy type of notice. I've been making the pitch over in Washington that type of termination should be viable under the CDC order, because the duration of the rental agreement is a collateral term outside of rent, and the CDC order doesn't allow those other terminations. But I think you're much better off having a cause basis to terminate tenancy even under the CDC order. And it's a little vague in how it would apply to something like that. But the declaration that's proffered by the declarant in the CDC process is a declaration that's all about money and all about non-payment of rent. So it's really hard to shoehorn that into some other type of defense to eviction or termination for other reasons.
We have a follow-up to that here too, that, you know, if hoarding, for instance, is declared as a mental health issue or can be construed as a disability, then you might be looking at a reasonable accommodation.
That's true. But I start all my hoarding cases with the allegations that the tenant is failing to clean and maintain the unit, that they're creating hazards by compromising dwelling safety systems such as heating systems, water heaters, that type of thing. And I started in that direction and go after the legitimate concerns, and then I wait for the tenant to say, "Hey, this is a product of a disability," and make an accommodation request. Go ahead, David.
Yeah, and Eric, I'm glad you brought this up, and this is a good topic to work towards an end of this session with. There is case law out there that finds hoarding is a disability. So Eric's exactly right. And people need to change their use of terminology here. You can't refer to somebody as a hoarder or do an eviction notice or a non-compliance notice that says you're violating your lease because you're a hoarder. That's no longer permitted. You're saying you're violating your lease because you have a disability. The truth is, and the approach that we must take to be accurate, is you're violating your lease because you're creating a safety and fire hazard by blocking areas of ingress and egress. The contents of your apartment is damaging the carpet. It's preventing us from doing our pest extermination and control. Things of that kind. It's causing moisture to build up on the inside of windows and mold to intrude into the sheetrock. Those are the types of things that have to be the reason for taking action. It can no longer be because you're a hoarder. Hoarder is a disability label. It would be the same as saying you can know you're violating your lease because you're blind. So, yeah.
Great point, David. What I like to talk about, and we'll talk about more of this in notice practice, is you use compliance notices or termination notices and use conclusory terms. You really need to be describing the conduct that's being engaged in by the tenant. And those notices, when you issue those notices to comply or vacate, advising the tenant what conduct they're precipitating or engaging in that constitutes a violation of their tenant duties, you're creating that exculpatory evidence that this is the legitimate reason that I'm taking action against this person. It's not because of some sort of conclusion that I'm making as to who this person is or what this person's all about. It's all about describing and defining their conduct with specificity and particularity. And in Washington right now, we have to do that to a great degree under our governor's proclamation that restricts our actions against tenants to significant immediate risk to health, safety, or property. And we have to be particular in our compliance and our termination notices, describing exactly what occurred, when, how, and why it's a violation of tenant duties that relates to health, safety, or risk to property. And I think those are great practice sentiments that David's articulated to understand the terminology and the nomenclature in your notices and your communications with tenants is gigantic, and it's never been more so. You have to be really thoughtful of how you articulate how the tenant's in violation of tenant duties. And I think the whole theme in fair housing is describe what's really going on and describe really what you're seeing, but don't make conclusory statements or attach conclusory names to that type of conduct, to that type of person.